So I am going to do some introductions. We are very excited to have with us today a wide array of folks. I'm starting with, first we have Patrick Cicero, who's the Executive Director of the Pennsylvania Utility Law Project, which is located in Harrisburg, PA, where he provides advocacy, training, consultation, and support services on energy and utility matters affecting low-income residents of Pennsylvania. Patrick serves as chairman of the Low-Income Home Energy Assistance Program Advisory Committee to the Secretary of the Pennsylvania Department of Human Services. He also sits as a member of the Pennsylvania Public Utility Commission Consumer Advisory Council and the Weatherization and Energy Conservation Policy Advisory Council to the Department of Community and Economic Development. Prior to joining PULP, Patrick worked as a staff attorney for nearly 5 years at Mid-Penn Legal Services, where he led their consumer unit and focused on consumer and housing issues. Patrick also worked for 3.5 years as the judicial law clerk to the Honorable Sylvia H. Rambo, United States District Court for the Middle District of Pennsylvania. Patrick has served as a lecturer at Pennsylvania State University, Dickinson School of Law, and the Pennsylvania Bar Institute, and is a visiting lecturer and an adjunct professor at Messiah College. Patrick received his JD from Temple University, Beasley School of Law in 2002, and his BA from Messiah College in 1999. John Rao is an attorney with the National Consumer Law Center, Inc., where he focuses on consumer credit, mortgage servicing, and bankruptcy issues. Mr. Rao frequently appears as a panelist and instructor of bankruptcy and consumer law trainings and conferences and serves as an expert witness in court cases. He has testified in Congress on bankruptcy and mortgage servicing matters. He is a contributing author and editor of NCLC's Consumer Bankruptcy Law and Practice and a co-author of NCLC's Foreclosures and Mortgage Servicing and Bankruptcy Basics. He is also a contributing author to Collier on Bankruptcy and the Collier Bankruptcy Practice Guide. Mr. Rao served as a member of the Federal Judicial Conference Advisory Committee on Bankruptcy Rules from 2006 to 2012, appointed by Chief Justice John Roberts. He is a conferee of the National Bankruptcy Conference, fellow of the American College of Bankruptcy, member of the editorial board of Collier on Bankruptcy, board member of the National Consumer Bankruptcy Rights Center, commissioner on the American Bankruptcy Institute's Commission on Consumer Bankruptcy, and former board member of the National Association of Consumer Bankruptcy Attorneys and the American Bankruptcy Institute. We also have on the call with us Charlie Herrick, who is a senior attorney for energy and utility issues at NCLC. He represents consumers before regulatory agencies, testifies at legislative hearings, and provides legal and policy counsel to low-income advocates, legal services lawyers, and government officials. He also devotes much of his time to training lawyers, advocates, and frontline social services staff regarding the rights of utility customers and contributes to NCLC manuals and publications. Much of his work also focuses on energy efficiency issues, including federal appliance efficiency standards, and advocating for larger and smarter energy efficiency investments in affordable multifamily housing and climate change. And last but not least is Carrie Smith, who is a senior staff attorney in the Homeownership and Consumer Rights Unit at Community Legal Services of Philadelphia, where she represents low-income consumers victimized by abusive predatory business practices and homeowners facing mortgage foreclosure. Ms. Smith also advocates on behalf of her clients before regulatory and legislative bodies. She is an expert on payday lending and has led a statewide coalition that has worked successfully to keep predatory payday loans out of Pennsylvania. Ms. Smith has a long-standing commitment to consumer advocacy and public interest work. She joined CLS as an independent foundation fellow after coordinating state-level consumer protection policy across the country for the National Association of State PIRGs. Prior to entering law school, Ms. Smith served with the Massachusetts Office of Consumer Affairs, where she oversaw the agency's alternative dispute resolution programs and a consumer information hotline. Ms. Smith is a member of the National Association of Consumer Advocates and the co-chair of the Pennsylvania chapter of NACA. She received the 2013 Legislative Advocate of the Year Award from NACA and the 2012 Excellence Award from the Pennsylvania Legal Aid Network, and was included in 2010 Next Generation of Leadership Rising Stars presented by Super Lawyers. Ms. Smith earned her undergraduate degree from Oberlin College and her law degree from Northeastern University School of Law, where she was one of 5 members of her class awarded the distinction of Public Interest Law Scholar with an academic scholarship in recognition of her commitment to public service. So we have 4 wonderful presenters today. Very excited to get moving with our presentation. And Patrick, I'm now going to hand it over to you.
Thanks, Tori. So we are looking forward to the ability to talk to you today about PACE. And I want to start with an introduction about what PACE is in general, and then we're going to talk about a few caveats that we have around our presentation. First, PACE, or Property Assessed Clean Energy Loans, are an alternate way to finance energy efficiency, renewable, or other home improvement products. The way that they're different than traditional lending products is, rather than having it be a securitized interest on the property like a mortgage is, the loans result in a property tax lien assessment. These are lien assessments that are senior to existing mortgages because they are authorized by the municipality in question. And when our presenters from NCLC, John and Charlie, they're going to talk a little bit more about the problem associated with that. But the loans themselves are actually not repaid to a bank, but rather through the tax collection system. They appear on the property tax bill of the property in question. These programs, because of this, have to be authorized both at the state and local level. In terms of the authorizing legislation at the state level, and then the municipality authorizing the putting of these loans on real estate tax assessment. The challenge associated with them is that they're not administered by the government, in that you don't apply to governmental entities. They're mostly privately run with a little and to no government oversight associated with who's taking them out, et cetera. How the loans are financed is typically through private securitizations, packaging loans together to get financing in the private equity markets, and also municipal bonds that are floated by municipalities. And so we're going to get into all of that in the context of this webinar, but I wanted to give you that brief overview about what we're talking about. We're not talking about energy efficiency grants. We're not talking about energy efficiency loans that appear on energy bills, and we're not talking about mortgage loans. We're talking about a system of loans that appear as property tax assessment liens. So what's the PA context for this? The PA context for this is that currently there's no PACE in PA. There's no authorizing legislation. However, there are 3 bills that are currently pending before the General Assembly. The bill that we are concerned about, and the one that we will be talking about in the context of this particular webinar, is House Bill 996. House Bill 996 was introduced and would allow both residential PACE, or R-PACE, and commercial PACE, C-PACE. And we'll get into, at the end of this webinar, exactly what House Bill 996 would allow and what some of the more specific concerns about that are. But House Bill 996 would currently allow this PACE program for residential consumers, and specifically including low-income residential consumers. The legislation in question actually specifically mentions low-income residential consumers. That's the crux of our concern. There are 2 other bills in the General Assembly, Senate Bill 234 and House Bill 1722, which are only commercial PACE bills, or C-PACE bills. And they specifically exempt, in the definition of real property that is eligible for these loans, residential and multifamily products. Currently, we do not have a concern about commercial PACE. We're agnostic to that. The concern that we do have is that we don't want either of those 2 bills amended to include residential. So we won't be talking much about Senate Bill 234 or House Bill 1722. They don't have what we consider to be the bad elements in them. Those bills are only related to commercial PACE. So the information that we're going to be talking about today does not is applicable to programs that would authorize residential PACE, and specifically in our context, House Bill 996. So again, just as I indicated, the concerns here about residential PACE and the impact, particularly for low-income and otherwise vulnerable customers. And so I'm going to turn it over now to our experts at the National Consumer Law Center, specifically Charlie Herrick, who will be presenting first about the growth of PACE and what are the concerns associated with residential PACE for low-income and otherwise vulnerable households.
Thank you, Patrick. And can you hear me? I just want to make sure I'm on.
Yes.
Okay. We are very concerned about residential consumers being impacted. And let me start with some of the things I've been looking at just in the last day or two. There are a large number of complaints coming out of California. Almost every complaint we hear about involves a senior or someone who's a limited speaker of English. And obviously that concerns us greatly. And as we go through the slides, I'll talk a little bit more about how the contractor practices are of real concern to us. So Patrick, do you advance the slides? Can you go to the next one? So PACE is growing at a truly astonishing rate. When we first started looking at PACE, there was a small program in Vermont and a kind of nascent program in California. But as you can see on the slide, it is now a multi-billion-dollar industry, even though those numbers reflect almost exclusively California. The programs in other states are either small in scope or very new. And the expectation is this industry is continuing to grow, and certainly the private parties, and I'll mention a few of those names in a moment, the private parties that literally profit from PACE and are its biggest promoters want it to grow as much as possible. So if you hear the names Renovate or Renew Financial or Y-Green, that's Y-G-R-E-N-E, those are the major entities that are the so-called program administrators. As Patrick mentioned, the state authorizes PACE to occur because it's really a change in the laws in your state regarding property tax assessments, and then a municipality, a county or a town or a city adopts it. But the vast majority of these loans are actually made through the work of so-called program administrators like Renew and Renovate. And I will say that I think of all the complaints we've seen, they are all connected to the program administrators and not places where the municipality administers directly. So the slide lists the places it's happening. California, I haven't done actual math, but I'd say it's 90% or more of the PACE loans have occurred there. Florida's fairly new. Missouri's fairly new. Vermont is not so new, but it's a very small and a very differently run program, and the same in Maine. So next slide, Patrick, or whoever is advancing.
Charlie, I apologize. You can advance the slides on the arrows at the bottom of the screen.
Okay. I didn't know if they worked. Okay.
Yep,
no, I can do it. I didn't realize those were activated for me. Thank you, Patrick. So the problems we see are real. I don't know how many on the call ever saw the movie Tin Men, which is about aluminum siding salesmen and the problems that occurred in that market. But PACE, for me, raises similar concerns. That is, a lot of money is now potentially available in the market to a set of contractors who then actually go door to door and make the sales. And I was just thinking about this yesterday. I'll bet there's a large percentage of those contractors who are completely honest, not looking to upsell, not looking to harm anybody, but even among those, there's some subset of customers who don't understand the deal and still get harmed. At the other extreme, though, and I think these are a lot of the complaints we're seeing, there are contractors who see an opportunity to mislead consumers and get them to buy things that are more expensive than they need to be and that are not necessarily useful or cost-effective for the consumer. So, we are seeing situations where a homeowner might need a small amount of work done to repair something, and the next thing they know, that contractor has done $40,000 of work to their home, including putting $25,000 of solar on the roof, and their property taxes might be going up $3,000 or $4,000 a year. So we've seen certainly complaints about unnecessary items being added to the scope of work, or things far more expensive than you would pay if you went to a contractor and got competitive bids. Another problem in the second bullet under some contractors have, it is common in the complaints we've seen that the contractor represents or says something like, this is a free government program, don't worry about it, or it's guaranteed to pay back, or the very misleading, you will receive tax benefits because if you're a low-income person with zero tax liability or small tax liability, tax credits just don't do you any good. And at the bottom of the slide points out that, in fact, this has unleashed thousands of contractors. And so even if some small percentage of those contractors are deliberately misleading people, that's an awful lot of harm that's happening out there. The next slide, PACE loans are high cost. I remember looking at this with John Rayo's help, about 3 years ago. He had access to what was the range of home equity loan rates at the time we looked at it, again, about 3 years ago. And then we looked at the PACE loan rates that were then prevailing in Berkeley, one of the very early programs. And it was very clear that you would be paying 3 or 4 percentage points above a home equity loan to get a PACE loan. One of the things we learned about the Berkeley program, which was closely analyzed, is many of the homeowners who went ahead with the energy measures did not use the PACE loan mechanism. They used the home equity line. And for those, you may encounter arguments, well, home equity is not really an option for a lot of people. Most PACE programs require that the homeowner have a certain non-trivial percentage of equity in the home. And if you have a non-trivial percentage of equity in your home, you usually can get a home equity line. So one of our many concerns is this is a very expensive way to go about doing energy improvements. In addition, there are a lot of fees, and again, these aren't the scale of mortgages. These aren't $400,000 loans or even $200,000 loans. So the fees actually drive up the annual percentage rates. And you see an example there. It is not that atypical to see an increase in the person's property taxes of $4,000, as you see in this case. And two things. For low-income people, obviously that's an extreme burden on their limited incomes. And it is almost impossible that energy savings would repay $4,000 in an increased tax assessment. Most people, their annual energy bills on the very low side, let's say, are $1,500. Most people, it would be $4,000 or less. So unless these investments are driving your energy bill to zero, it's just not going to pay back. And so the next slide, energy concerns, particularly for low-income people. So in Pennsylvania, you have some good utility programs. Every state has a federal weatherization program. Low-income people should be directed to those programs first. We do not see that happening in California. That's one of our concerns. Another thing that I find quite surprising, I'm the energy advocate from NCLC on the call. John's more on the consumer finance side. I am almost shocked that PACE doesn't require energy audits. All the energy programs we work with or advocate around require energy audits because it makes good sense to figure out, is that investment cost effective? So the bottom line concern here on this slide is that really, particularly for low-income people, we should be directing them to investments that really reduce their energy bills more than the cost of the investment. It's fair to point out, I have no doubt that many middle and upper income people in California are consciously choosing for very legitimate environmental reasons to invest in photovoltaics. They may have a long time horizon because they're not short on cash. If you can fully take advantage of all the tax benefits, which middle and upper income people can, it also may actually be cost effective. But for low income people, it's usually not cost effective to be investing anywhere near the amount that we see in the PACE loans. And I guess I'll close with just one number on that point. When we look at California, and there's actually a lot of data now, Average PACE loans are running $20,000 to $25,000. That's not weatherizing the person's home, and it's not even replacing the heating system. It's quite often those things and solar photovoltaics, which just aren't a cost-effective investment for a low-income person in most cases. So with that, I think I'm up to passing it off to John Rayo.
Thanks, Charlie. So what I'm going to talk about briefly are some of the major consumer protection concerns we have. They're really quite longer list than this, but this is what we will focus on initially. And clearly the most important concern we have is that PACE loans are, at least in California, are not being made with any screening of whether the consumer has an ability to repay. I mean, one of the lessons that we learned from the foreclosure crisis that started, in 2008 is that you really can't make loans that are secured by someone's home without considering whether they can repay the loan. And most certainly you can't be making those loans just based on unverified stated income. But that is exactly what's happening now in California. You may learn, actually, this webinar is being held on the day that the California legislature is voting on a bill that would add some additional consumer protections to their statute. We are just, you may hear about this, and I just wanted to make clear that we are not supportive of the measures that are being taken in that bill. It just simply doesn't go too far. It's a good start, and it starts on the conversation of that there should be ability to repay screening, but there's too many loopholes, and there's an emergency exception that we're concerned about. So we feel as though it doesn't go far enough. So as you're considering what might happen in Pennsylvania, I don't think you should look to what California will probably do today in their statute on that issue. The other things that we find when we're looking particularly at the enabling statutes, so as was mentioned, there are 5 or so states where there are active programs, and really outside of California, most of those are pretty small at this point, although Florida is growing quickly. But many states have enabling statutes that have already passed, some sort of like the bill that Patrick mentioned that's been introduced, House Bill 996, which don't have much. They authorize PACE loans, but they don't include much in terms of, or anything in terms of consumer protections. And so most of the statutes do not address what kind of disclosures should be given by either the program administrator or the local government to the consumer before they enter into the contract. California does have a disclosure provisions, but importantly, at least from our concern, is that they do not require advanced disclosures like we have under federal law if you were to take out a mortgage. We think at a minimum the homeowner should get those disclosures of just the true cost of the loan at least 3 days before they finally commit themselves to the assessment contract. We also think, and this is something that very few statutes, the PACE statutes address, although California does, but in an incomplete way, and that is whether or not the borrower can rescind the contract if they decide to change their mind. Under federal law, particularly, well, for a refinance mortgage, you can rescind within 3 business days. And we think that a similar provision should be with the PACE assessment contracts, but there really needs to be a coordination between the contract that the homeowner enters into with the contractor and the assessment contract. These actually are 2 different things. They shouldn't be, but at least that's how it's working in California. So someone might, so if there is, to make this short, if there is a rescission period for the assessment, the PACE assessment contract, which we think there should be, no work on the improvement should begin until that 3-day period is expired. And what we're seeing in California is that the contractors start work before that rescission period expires, and that puts the homeowner in a difficult position where maybe they rescinded the assessment contract, but now they're still on the hook for the improvements that were made or started by the contractor, and there might be a mechanics lien put on the property. Lots of really serious concerns there. Finally, one of the major provisions we think needs to be included, and this is really not addressed in the California law directly anyway, is what to do when the contractor really is engaging in fraudulent activity, as Charlie mentioned, or they just do shoddy work. Outside of PACE, there's a requirement that under the Federal Trade Commission holder rule that you could assert as a defense to the bank trying to collect on the home improvement contract the fact that the contractor didn't do the work properly or committed some other fraudulent acts or something. There's nothing like that currently under PACE, and we think there needs to be something like that. It can maybe tie into, I'm not familiar with Pennsylvania laws on contractor licensing, and some states have a reserve fund that's created for homeowners to access if there are problems with contractors. I don't know if something like that exists in the Pennsylvania law, but that's something that you could try to tie into. Let me move on to the next issue. So another concern is what happens after the loan's been made and the homeowner either wants to sell the property or refinance. The industry says that there's nothing to worry about here because PACE assessments are assumable, but you may be familiar with the fact that Fannie Mae and Freddie Mac currently will not purchase loans where there's a PACE assessment that's in a senior lien position. Now, Fannie and Freddie may change that. We have some belief that that may change fairly soon, but at least at the present point, that is a concern. And then there's the whole question about whether someone you might want to sell your house to will take over making payments on the PACE loan or require that you pay the PACE loan off before sale. And a lot of that has to do with the fact that if it's some improvement that was, let's say it's solar panels, and they've 5 years from now or even 10 years from now, and many of these loans, by the way, have 20-year terms or 25-year terms. But let's say 10 years from now, you go to sell the property, the new homeowner, the purchaser might say, look, I don't want to pay for this because there's much better products out there that I could have used, and I don't want to be paying for some old tech that's not very efficient. And so, and let me give you another example. I'll do this quickly because I know we want to cover some others. But this story from California kind of really points out a lot of the problems. We were contacted by a woman in New York whose mother lives in California, and she was about to put her mother, help her get into assisted living because she's been diagnosed with dementia. Well, it turns, and part of the move to assisted living was that her home would be sold. And the daughter wasn't even aware of this because I think the mother, had been she suffers from dementia. I think a contractor really took advantage of her. And it turns out that when they went to sell the property, that she found out that there was a $22,000 PACE loan. And so they thought, well, okay, that's fine. And the purchaser of the property said, fine, I'll assume that. But then when they went to go close on the property, the realtor found that there was yet another PACE loan on the property for $49,000, and there was no paperwork, and the purchaser just said, look, I'm not going to pay, I'm not going to assume that. You have to pay that off. And so money that from the sale that was going to go to help pay for the mother's assisted living, now is going to be absorbed by this PACE loan. So really a horrible story. And you might wonder how these loans were even made. The mother was, her only income was from Social Security, and it was fairly small and clearly was not enough to support these loans. So it truly is an awful story of some of the real abuses with PACE. And by the way, we're seeing this problem of contractors using different providers, so either Y-Green or Renew or Renovate, and so they're splitting these into two contracts so they can try to get more approved, essentially. And the way it works in California, these things don't show up necessarily quickly on the Land Records Office. And so that's another evasive process being used to oversell these loans. And just a final point on this issue is that it can also be a problem when the homeowner tries to refinance, particularly if they're trying to use a Fannie or Freddie loan, or if they're trying to get a loan modification if they're in a foreclosure, potential foreclosure situation. So these loans, as Patrick mentioned, are structured as tax assessments, so they run through the tax system, and as a result, they are, whether this was done intentionally or not, I mean, clearly they were done for other reasons to be treated that way, but the effect of them is that most consumer protection statutes don't apply because most of the statutes refer to credit as being the trigger for whether or not the statute applies. Now, we actually do have some arguments that we believe that the Truth in Lending Act does apply to PACE loans, but you know, I'm not sure whether the courts would agree, but just wanted to make clear that there is an argument that they would apply. And there is an effort, there's a bill in Congress right now to try to make these loans clearly subject to TILA, and we're not sure where that is headed, but that's another thing to keep in mind. Another concern is that almost all of these state statutes, the enabling statutes that I've looked at, probably all of them, do not have any remedy provision that a consumer can use if they need to go to court and try to get relief. In California, it's not so much of a problem because they have this really fabulous unfair and deceptive acts and practices statute that can probably be used against at least the program administrators and the contractors. Unclear whether it would apply to any of the government entities that are involved in the process. But one of the things we think should be in these statutes is some form of express remedy that a homeowner would have if there are problems. The other thing that we are concerned and think that state law should prohibit are any kinds of forced arbitration in these contracts or waivers, and we are seeing those in the California contracts. And also just broad releases and waiver clauses. So we think those should not be included as well. The final thing, it's not on the screen, but another point is that, and to bear in mind, particularly as you're looking as to what might happen in Pennsylvania, is because these are treated as assessments and they run through the tax system, it also means that the provisions of your state law that apply to taxes and special assessments will apply. And I don't know, I meant to check this and I couldn't find it easily. I'm familiar with a lot of the state tax statutes and tax sales statutes, but most all of them do have a provision that if the assessment if there's non-payment of the assessment, that in addition to that penalties and interest will accrue on the assessment from the date of non-payment. So in California, this is becoming a really big problem. So not only, as Charlie mentioned, are these high-cost loans, and there's interest that's already built into the assessment contract, but once the homeowner falls behind on an assessment payment, then there's additional interest and penalty that applies. So these can be really costly loans when you add in that as well. And then there's the concern about what happens if the borrower does fall behind, particularly if it's not a non-escrow loan, and that where it might be a senior who doesn't have a mortgage on the property. That it could then go into the tax sale foreclosure process, and that process in some states can both be very quick and also have very few consumer protections. So I think I'll turn it back to Patrick at this point.
Yeah, thanks, John and Charlie. So we are going to spend a little bit of time talking specifically about House Bill 996. And so part of the goal of this webinar was to educate all of you who are joining us, and as well about what we believe are the pretty inherent dangers with residential PACE. And again, currently House Bill 996, which was introduced this session, and it's been introduced in previous sessions, remains in committee and remains in the Environmental Resources and Energy Committee. And the challenge associated with this is multifold. One is that particular committee has not historically done work around consumer protection issues, right? It's not in the Consumer Affairs Committee, which is the House committee that deals with our unfair trade practices law, which is the House committee that also has oversight over the Public Utility Commission and the utility issues that historically come before the General Assembly. And so House Bill 996, as I mentioned at the beginning of this session, really has broad language in it authorizing PACE for residential customers. It also authorizes commercial PACE, but our concern again is residential PACE. And it authorizes residential customers to, in our judgment, it unleashes all of the potential parade of horribles that could happen with residential PACE that Charlie and John just spoke about without any level of consumer protection whatsoever. And particularly pernicious in my judgment is that there's not any tie-in to energy savings. There's not any auditing requirements, as Charlie mentioned, and none of the ability to repay, truth in lending protections, or any other of the protections that John was just talking about would come into play. And this provides, from our perspective, pretty rampant opportunities for these loans to be the next subprime lending crisis. Pennsylvania has already had havoc wreaked upon it as a result of the subprime mortgage lending crisis. And for the context of residential PACE, we view this as kind of substantially similar in terms of the vulnerability of households not understanding what's going on. Among the more challenging aspects of House Bill 996 is not only does it authorize property assessed clean energy loans, PACE, residential PACE loans for energy efficiency improvements that may have the likelihood of reducing energy consumption and consequently freeing up funds to pay for the loan. It also authorizes what the statute or the bill refers to as green wet weather infrastructure improvements, which are improvements to, among other things, residential properties that maintain or mimic natural systems to recycle stormwater. And while that may be beneficial, and certainly from an environmental perspective, we have stormwater management problems in Pennsylvania, it's not the same kind of project that would necessarily promote savings of utility bills that would enable individuals to pay back this loan. So we can send out House Bill 996, or those of you who are familiar with how to find that are certainly able to find all of the problems associated with it. But one of our goals from this webinar is to see whether or not there's kind of a concerted cohort of individuals interested in educating legislators about the risks associated with residential PACE. And starting with the sponsors listed here of House Bill 996 and trying to ensure that this bill, from our perspective, that it either A, does not go anywhere, but if it does, that the legislators and staff are educated about the risks and the needed improvements. And so I'm going to turn this portion over and share this responsibility of talking now with Carrie Smith, who's with Community Legal Services. And Carrie, I don't know, in addition to talking about kind of this education and kind of coalition building strategy that we have, if you are able to address any of John's questions as it relates to property tax assessments and that process in Pennsylvania, given the work you're doing at CLS.
Yeah, I think I'm not sure that we would have much that would be applicable statewide, since we have a very specific statute related to the tax collection process in Philadelphia. But we can certainly share in the future information about our experience here in Philadelphia with others. I mean, in terms of House Bill 996, I mean, I think the work that I don't think we're in a crisis mode right now. This residential PACE bill, unlike the commercial PACE bills where literally almost half of the Pennsylvania Senate has co-sponsored it, it doesn't appear to have a lot of momentum. The bill was filed in March. As you indicated, it's been in committee. There's a handful of co-sponsors, one of whom is in the minority party. But of course, this is Harrisburg, and anything in Harrisburg can really change on a dime. I think probably one of the first things for interested parties to do here is to start reaching out to the lead sponsor, John Galloway, who's from Bucks County, as well as the other sponsors, because most likely this bill comes from good intentions. After all, we've got energy efficiency programs can be a really useful tool to help low-income consumers reduce their energy costs. But I think, as John and Charlie so effectively relayed earlier in the webinar, the stories that are coming out of California in particular of these residential PACE programs, they really are just a haunting echo of what we saw our clients face during the subprime mortgage crisis, with home improvement contractors knocking on doors, soliciting really vulnerable people for home repairs they might not necessarily need or never get completed, or where the work is shoddy and the contractor disappears, leaving the homeowner with a really costly loan that they maybe never understood, and that puts them at risk of foreclosure. So I think what we want to do to begin is just start with educating these sponsors and sharing that information with them. But we also need to build a team of leaders working on this, and today's webinar is a start. And there's also some possible opportunities for homeowner advocates to partner with unusual allies. Because these PACE loans are tax liens, they typically become sort of a super priority lien ahead of any existing mortgage. So I think, as John had mentioned, homeowners often have trouble refinancing or selling their home without paying off that lien in full. And so mortgage bankers and realtors have expressed concerns about the PACE program. So we have an opportunity here in Pennsylvania to be reaching out to the Pennsylvania Banking Association and realtors to see if we can team up together to educate people about the risks of residential PACE. So how can you be involved, folks on the call today? You can simply let Patrick and I know if you'd like to join our efforts. And to make that easier, we did create an online sign up. There's a link here on the screen. It's a short bit.ly residential PACE sign up where you can add your information, and we can continue to keep you activated and updated as things develop on PACE. And I think in the very near future we'll be circulating a sign-on letter, and there'll be opportunities to come to district meetings and the like. In particular, if you have relationships with any of the co-sponsors or the Pennsylvania bankers and realtors, you should let us know so we can make the most effective connections. And we'd also like to hear your ideas as well, so please feel free to weigh in or to reach out to us.
Yeah, great. So we're interested in providing this as an opportunity to do a little coalition building. I know that there are a number of individuals on the call who have actually interest in commercial PACE, and so as I indicated many times, our current concerns are not related to interests in commercial PACE. That said, I think we're probably, in addition to a sign-on letter that would be targeted to the sponsors of House Bill 996 and others in the General Assembly about House Bill 996, likely to continue to reach out to members of the General Assembly about the other PACE bills to just say, please do not add authorizing language here that would enable residential PACE, so that we can warn, from our perspective, warn about some of the challenges associated with that. So there are some resources too, in addition to the bit.ly that Carrie mentioned, which is your opportunity to kind of continue to get some information on this or be a part of a coalition. There are resources available on National Consumer Law Center, NCLC's website, as well as some other reports. When we send out the webinar slides later today, I'll make sure that each of these is activated, so each of the links is activated so that it can direct you to to the source. So there is some good information out there about PACE, including primers about residential PACE that we have concerns about. There's also kind of this best practice guidelines for residential PACE financing that DOE put out. And Charlie and John, I don't know if you want to talk with a few minutes here about that. In my understanding, and please correct me if I'm wrong, is that there are some things from our perspective that are good about DOE's best practices, but they haven't adopted what NCLC or other consumer and low-income utility advocates would believe are kind of the core best practices for residential PACE financing. And I don't know if either of you can talk about that or any concerns you might have about DOE's guidelines.
Patrick, this is Charlie. I can jump in on that. So the release of draft guidelines is what got us fully engaged with PACE policy issues. There was a draft set of best practices under the Obama administration. The Department of Energy and actually people in the White House itself were very keen on promoting PACE. They came out with the guidelines hoping that it would promote the growth of PACE. We were very concerned that those guidelines were too weak by far on the consumer protections. We had extensive discussions with various agencies in Washington. Those guidelines were much improved. But the bottom line is kind of what John said about the California legislation. There are some good things in the guidelines. There are very few bad things in the guidelines, but the good things are too limited and don't address key issues like ability to repay or requiring energy audits. So it's worth looking at. I do want to, if I can, follow up on something Carrie said that's very key. She said that, I don't know who those legislators are, but she said they were probably well-intentioned. And I will say that in most states, PACE legislation starts from people who are concerned about the environment, which is obviously an incredibly important public policy issue. They are often people who haven't thought deeply about the potential consumer impacts, adverse impacts. And so in our experience, it is useful to engage the environmental community. I know that somebody from NRDC signed up for the call. I'm not sure they're actually on the call, but Patrick or Carrie, I'm happy to have further discussions. I'll just say here, we've had extensive discussions, particularly with NRDC and ACEEE, the American Council on an Energy Efficient Economy. And when we have these conversations, I think people's eyes are open. When we share the kinds of stories that John shared, their eyes are opened and they're still supporters of PACE, but they also become supporters of incorporating the consumer protections. So I would encourage you as you do your legislative work, great to get the bankers on board, but it would also be good to educate some of the environmental groups and have them potentially be allies on the consumer protections.
Yeah, I think that's an important point. I do know that Mark Shebist is on the phone. At least I see him being on the phone, and we've had these conversations too. And so, yeah, I mean, we have local and national support for most of the advocates who I've spoken to are interested in commercial PACE, and there hasn't been a real push from the environmental community, both locally or nationally in Pennsylvania, for residential PACE, and we're certainly supportive of their support of our concerns as we try to stay out of the way of their concerns with regard to commercial PACE. It's just a delicate balance. But John, were you going to say something? I apologize.
Yeah, in response to the question about the DOE guidelines, we are, and also just in terms of resources, we do have a page on the NCLC website that's devoted to PACE, and we are going to be putting up very soon a list of what we consider to be recommendations for state legislation that I think goes beyond the DOE guidelines and is more focused on the specific consumer protections that we think should be in the statutes. And we've been revising it over time as we hear more and more of the more specific problems that are occurring, particularly in California. The other thing that we're going to be putting on the website probably next week is we've been collecting stories from legal services attorneys and other advocates in California about the cases that are walking into their doors with PACE problems, and it's a little it's quite revealing, and hopefully you will want to take a look at that. Finally, in terms of where to go, where you should to think of alternatives or other approaches for your legislation, I should just point out that in Minnesota there was a bill pending, sort of like the bill you have on residential PACE, and the Minnesota legislature decided to defer, and there were concerns about consumer protections that were being raised by consumer advocates and the mortgage industry, and the legislature decided to create a task force to look and to report back to the legislature on what should be included in legislation to address consumer protection. That task force is meeting, and they're very active. I made a presentation to them a few weeks ago, and you might want to just look at what's happening in Minnesota, because I think they're really trying to look at this carefully and to get the protections in the law before the programs begin. So another thing to take a look at.
If I can, Patrick, John has given me a wonderful opportunity to play Massachusetts chauvinist. In Massachusetts, we have a zero-interest loan program that lends about $50 million a year and creates none of these risks. We even have the entire environmental community in Massachusetts saying we don't need residential PACE. It's, so you have utility dollars for energy efficiency. We take some of our utility dollars for a deeply subsidized loan program that does not go anywhere near the property tax assessment system, and it's also run from local community banks. That is not the national banks, but Massachusetts-based banks, and we just have not heard a complaint about any of those loans. So, in addition to the Minnesota statutory model, a different way to go about this, I'd also say there's a different program model that, in states that have utility funding, you can build a really good residential lending program that just doesn't create any of these risks. And happy to share details about the Massachusetts loan program.
Yeah, thanks, Charlie and John. I think those are really important points. I mean, many folks on the call know about our in Pennsylvania. We don't have quite a robust zero-interest energy efficiency loan program. We do have some loan programs, Keystone loan programs, and we certainly have lots and lots on the electric side anyway of programs designed to promote energy efficiency and utility affordability for low-income households. And so we didn't talk a lot about what the alternatives are for residential customers, and many of the alternatives are limited to income qualified customers. But the dangers that Charlie and John mentioned are just so inherent, and we believe, based on previous experience with loan products that are substantially similar to this, that the targeted households are households that would otherwise be eligible for these measures anyway. So you have on this slide here all of our email addresses, so you can email us with questions, concerns, or any other information that you want to know, either about our organizations or opinions about PACE or anything containing in this webinar. As Tori mentioned, the slides will be sent out to all webinar participants, as well as a recording of the webinar. And again, I'll ensure that the links on the slides are direct you to the right place when you click on them, including the bit.ly that Carrie mentioned. That's all I have, unless Carrie, John, or Charlie has anything else. I think I'll turn it back over to you, Tori.
Great. Thanks, Patrick, and thanks, John, Charlie, and Carrie, for presenting today. We just have a few minutes left, but I just want to open it up, unmute everybody. I will unmute everyone, and I just want to open it up quickly for any comments or questions, and would also like to know, Patrick, if there's going to be any follow-up in terms of the advocacy aspect of this. So I'm going to unmute the line for any questions or comments. And
the conference has been unmuted.
And maybe, Patrick, you can also address the advocacy aspect.
Sure, I'll address that after we hear from folks.
Any questions or comments? Everyone is unmuted.
Hi, this is Eric Miller from Kia. I do have a question, either for John or Charlie. I know it sounds like I know that most of the activity around PACE, residential PACE, happens in California. I was wondering whether either of you could touch on Vermont or Maine's program and what differences there are. I haven't heard, the same level of negative stories from other states, and is that a reflection of fundamental differences in their programs, or just that they're not as big yet?
Well, as I mentioned, this is Charlie, and good to hear from you, Eric. As I mentioned earlier, Vermont's program is not new. It's I don't know if it's as old as California. It is a different model. I haven't looked at it recently, but my recollection is it's run directly, I think, through Energy Efficiency Vermont or some other government entity. And I will more generally make the point that, I forget if John and I both of us spoke to the counties in California that run it directly. When government runs it, they don't have an interest in expanding it as quickly as possible simply for the sake of expanding it quickly. So my recollection is Vermont, it's smaller size loans. It really is focused on the building envelope and getting consumption down and not trying to go as big as possible in each house. And so we've heard of, I think, no complaints from Vermont, even though that program's been running for a while. In my recollection, maybe John knows more, Maine is also a small program, not because it's new, but they're just not interested in getting the contractors out on the street and expanding it as much as possible. In particular, we spoke to Placer County, California, which runs it directly. We were connected with that county by PACE Nation, which is kind of the industry association, and yet that county treasurer was as concerned about as we are that the program is being oversold in the places where it's not run directly by government, and that she was concerned there's going to be a big wave of tax actions that are going to start to be taken around California, like we saw in the subprime mortgage problem, which is after a few years, the house of cards comes tumbling down. But I'll let John add in, because I haven't looked at Maine and Vermont in a while.
Actually, I don't have anything to add on that, Charlie. I haven't focused on either of those states.
Great, thank you. Any additional questions or comments before we end the webinar?
So hearing none, Tori, this is Patrick. Just to get back to the follow-up, one of the reasons why Carrie put together that bit.ly link is so that you can leave your name and information if you're interested in follow-up. We don't want to bombard folks with follow-up who just signed up to learn more about this or had concerns about it. So if you're interested in follow-up, we would encourage you, when you get the webinar slides, to go to the bit.ly link that will be available to sign up, and we'll be following up both with the educational opportunities that exist and opportunities to sign on, perhaps to a sign-on letter or two. So, of course, if you're interested and you don't want to do that, you're always welcome to email Carrie or myself, and we'll be happy to speak to any of you by phone or email as well.
Great. Thank you so much. And again, thanks to all the presenters for getting on the phone today and taking an hour of your time to talk to us about this topic. I hope you all have a wonderful weekend, and thanks again for joining us today. Take care.
Thank you.